Showing on Law Weekly today, we discuss law and justice in Nigeria before, during, and after COVID-19. We have the views of a senior advocate of Nigeria, Candide Johnson. Also showing on the program, Lagos punishes violators of lockdown directives, sends signals that it would not tolerate disobedience and wants all to join in efforts to curb the spread of the coronavirus. That's our lineup on this episode of the program. Hello and welcome. I'm Shola Sheyeli. Let's go straight away to our conversation. Senior Advocate of Nigeria, Candide Johnson, is passionate about judicial reforms. He's spoken several times on this and authored so many articles in this regard. In his latest article titled Law and Justice in Nigeria After COVID-19, he makes the point that the delivery of equal justice to the widest group of Nigerians is a cruel mirage. Amongst other things, he says that the Nigerian judiciary lacks a 21st century vision and there's an absence of an overarching judicial ideology. Such a sad commentary. But how did things get so bad? This was the first question I put to him.
From the time that the form of judiciary we have operating today was created by the British in 1860, 1870s, to serve specific purposes, the defense of a particular political order and the regulation of society in a way that was understood by those people who ruled us then, that we have had a succession of successors who delight in the ceremony and the grandeur of the office without understanding the purpose for which it's meant to serve. Judiciary is an instrument of government, and government is about regulating order in society. What is the purpose of the judiciary? It's to decide disputes as a mechanism for societal regulation, for control. The overarching philosophy of the judiciary must be understood by those who administer justice in those courts. What are we trying to achieve? So, for example, if you recognize that the governance purpose in the judiciary is to diffuse social tensions and facilitate the improvement of business by resolving disputes, then you recognize that the sooner you do that, the better. The more efficient way you do that, the better. And that you need to do it in a way that people who leave the courts understand they had a fair shake and that they will abide voluntarily by the decision of the courts. This is a philosophy. If that is a philosophy, it guides every aspect of the operation of the courts. If you don't have a philosophy, then you think that the end of your office is your gown, your robe, the appellation and the ceremony, then this is why I use the expression in that article to which you refer, that what you will have is a group of well-fed Africans in 17th century English court dress doing nothing in particular.
The leadership issue and some of these things you've talked about are some of the problems why the courts in Nigeria have ground to a halt despite COVID-19. But would you share with us how other developed countries have been able to ensure what you call continuity of governance?
I think that in the present emergency, what you see is the activation of a well-visioned administration. Because in any enterprise, in a school to which I'm a director of, in my office, we have a business continuity plan. There may be civil strife, there may be floods, there may be natural catastrophe. You have to say, if you're running a business, how will you continue to deliver your services and earn income when something strikes, disaster strikes? It could be something blows up your computer server. So businesses do this as a matter of course. Across the world, governments do this as well. Governments have governance continuity plans. If you look up judicial governance continuity plans, you will see the plan for Kenya. I was reading an article just now about Arizona and Texas, New York, but let's not go so far. Ghana, Sierra Leone, Rwanda.
African countries.
So African countries, because we say, oh well, you see, the white man did something different. There's nothing different that anybody does. All it means is that you have to apply yourself to the necessity of your governance. What we have seen in Nigeria is the exposure of sustained systematic incompetence, planlessness, lack of vision. And when I say again that some people act differently, you will notice that recently the President of the Court of Appeal, acting President, attempted to issue guidelines for operating remotely and for urgent matters. Within 24 hours, the Chief Justice of Nigeria had issued another letter saying that courts were to be suspended indefinitely. So clearly, the President of the Court of Appeal understood that there's necessity for law and justice to continue, where perhaps the Chief Justice of Nigeria may not.
If we have a leadership problem, one person, maybe the Chief Justice, and I'm just assuming if it's the Chief Justice of Nigeria who doesn't quite understand why they are there. But if we have other judges in the system, like you've given us the example of the Court of Appeal President.
Yes.
If we have other judges, couldn't they together collectively overrule that one person who's not in tandem?
First thing, and I don't want to talk in particular about the Chief Justice, but he's issued circulars which do not reflect an understanding of the necessity of justice or of the administration of justice in a time of crisis. But many of these things are issues that can be devolved on states. I spoke about the Court of Appeal President taking steps appropriate to her own court. Lagos State is my own state. Lagos State has also suspended sittings except for urgent and particular matters. There's no way that is defined. There's no indication administratively how to access the registry, how to access the premises, how to make filing. If you recognize that deciding disputes is important for societal stability and progress, you will make an effort to resolve those cases. If you think it's just a fancy thing for people to come and call you my lord and make a pointless dance before you, then you can afford to postpone them indefinitely. What this crisis shows as far as our administration of justice is concerned is that judicial administration in Nigeria, by and large, is unresponsive to the needs of society, to the necessity of their own function. And this is a problem of personnel. Because in any court in Nigeria, I can name judges who I have discussions with who understand what is needed. And it's not, I know judges in Lagos, I know judges in Borno State. Chief Judge of Borno State, for example, is a far-thinking intellectual who understands the necessity of judicial administration. But even though
So you think that we don't have a lot of forward-thinking judges?
I think we have a lot of forward-thinking judges.
Okay.
I think that we don't have a lot of forward-thinking heads of courts.
Okay, so let's talk more about some of the things that we failed to put in place. What we can learn from African countries and other developed judiciaries across the world.
If you look at other countries, they recognize what is fundamental in this COVID crisis. The fundamental fact in the COVID crisis links directly to available technology. You cannot have people in close proximity to themselves. To the highest degree possible, they should be avoided. Does this mean you can't work? Of course not. Just 5 minutes before I came in here, I was on a Zoom meeting with staff and students of a school, 20 people on one screen, everybody from their own house. In my office, I had a staff meeting this morning. 10 lawyers discussing a case on one screen. This is inexpensive technology. If you ask 9 out of 10 judges in Lagos, they may not have had a Zoom meeting before. Why not? For many years, this technology has been available in a variety of platforms. If you go to the UK website, they talk about Skype, they talk about Zoom, they talk about GoToMeeting. There are a number of platforms which are secure in their own way, which self-record, which can hold a number of participants at the same time. That technology is available. There is a legal question as to whether a hearing is in public, which I have my own clear thoughts about, because this is a question that has to be interpreted in light of the circumstances you confront yourself with. You can't hide behind the letter of the law when your primary function is to provide solutions to the people. In a recent case in Zimbabwe, which demonstrated again, Zimbabwe, they had a case, a constitutional case which arose as to whether steps taken by regulation by the government in respect to this COVID crisis could be stopped by a private party. He went to court. The case was argued on the 29th of March and the 31st of March. On the 1st of April, the judge gave a 12-page judgment. No one has ever heard of such a thing in this country, but it was well thought out, well articulated. He explained the emergency, the urgency, and the reason why I'm referring to that case, not just because of the efficiency displayed in that court, is because the judge said, quote, and made a Latin quotation, that the health of the people is the supreme law. In the Nigerian Constitution, the safety and security of Nigerian people is a fundamental of our Constitution, as it should be. There's no point having a society if you can't protect the health and security of the individuals. You might as well just go and sleep and let everybody go back to the jungle.
So we can't say that because our laws haven't provided for technology, we can't use it.
You must find a solution. This is why the black letter of law is given to human beings to administer, because they must administer it on every given day according to the exigencies of the situation.
According to the exigencies of the situation.
And we've had many examples of that in Nigeria, most in the political field. When you want to decide whether there's a necessity to change the president, they find a solution. When you want to decide whether someone is no longer a deputy governor who's elected can succeed to the governorship, they find a solution. Because the Constitution and law must have flexibility in its joints. The people who write a law cannot foresee every situation. But this situation has been foreseen for a long time. So the question is, with all these platforms available, why is it that the Chief Justice of Nigeria didn't say to himself, we have a crisis, we have a duty to administer justice, this is a constitutional function, we're public servants, we're being paid for it. But we have a medical emergency which makes it difficult for us to meet physically. Therefore, I want to know what are the solutions we have. And someone has said, sir, have you heard of Skype? Sir, have you heard of Zoom? What is that? Well, it's a technological platform which is easily accessible and inexpensive, by which 10, 20, 30 people can attend a meeting at one stage. Okay, there are many cases we can resolve in that way. Unless a case requires physical attendance, and even cases where witnesses are to be called, you can hear those cases. You do this in arbitration all the time. So that's a question of a public hearing. Another big aspect of our work is motions and applications. In many courts across the world, motions and applications are decided without parties appearing. The President of the Court of Appeal said that if you have a motion in her direction, you should state what the purpose is, the dates, the parties involved. This is a one-page document. And in courts in America and many other states, they will determine the motion on that basis alone. You get an email letter saying, yesterday the court considered your motion and they made this decision. That's very simple. That's 60 to 70% of the work done by the courts each day. It's simple. It's just a matter of applying common sense to the solutions to the problems we face every day.
So in specific terms, how can the Nigerian judiciary get on board? What are the things that the leadership of the bench must do?
There are many things that can be done. As I said, 6% of judicial work is interlocutory applications. You don't need to have a court appearance to decide an interlocutory application. If you say interlocutory, and now all the courts submit written arguments and motions. So you can say to the lawyer, your motion dated 10th of June is going to be considered. You're entitled to file a one-page summary. You will decide on a one-page summary. End of story. That takes care of a lot of your business. Hearings and arguments can be done by basic and simple technology. There are many ways the business of the court could have been organized much better. In the Supreme Court, reduce the number of cases that you hear, reducing interlocutory applications, refusing applications for extension of time, calling for a rational evaluation of all the cases before the courts. Some cases they're asking for leave out of time. It's not going to be granted, it's not necessary. You must fulfill the conditions of the time. One of the revolutionary aspects of the modern judicial attitude across the world is that the rules of the court are meant to ensure that the limited resources of the court and limited time is available to the largest number of people in that time. So a court has 10 hours a day. How many cases can you decide? Why? Because there are 500 people who want the case decided that day. So you tell everybody, have 10 hours, every case has 30 minutes. I don't care whether you're a senior advocate or whether you're the Attorney General.
We need to start to set time limits.
Absolutely. It's docket control. So I know once I file a case on the 30th of June, by the 30th of August, I will have a date. It's clockwork. That case will tell me that my case has been evaluated. It's been determined that it involves a high amount of money, it involves an issue of general public importance, it involves so number of witnesses. I want from each party a proposal as to directions for hearing. Each party submits, the judge looks at it and says, okay, you're going to get 10 days, you're going to get 10 days, you're going to get 10 days. This case will be fixed for hearing on the 1st of December. And that date must be kept. So some big lawyer turns up without nothing to say and starts mumbling on about how carelessly he hasn't prepared his case because he has something else to do.
And he wants an adjournment.
You strike out his case. Because access to justice requires that the person who can afford an SAN should have the same rights as the person who can't. You know, people think that the rank of SAN is some sort of priesthood, some sort of royalty. I don't have that feeling. I consider the ascription of leadership in any profession to be a responsibility. So if you're a professor of medicine, I expect you to know more and behave better than an intern. So if you're a senior advocate of Nigeria, I expect you to exemplify the highest quality of your profession to the best degree. So I've said this to many people. If I'm sitting as a judge and a senior advocate is appearing in the case and the junior is appearing in the case, if the junior needs 30 minutes, I'd say to the senior advocate, Silk, of course you don't need more than 10 minutes to summarize your case. If he has legal knowledge, if he has the power of expression, and he hasn't just inherited the rank of SAN or had it given to him as a political or social favor, then he should be able to express himself with clarity, with brevity, and with comprehension.